Thank you, Mr. Acting President. There is so much to cover with this bill, it is difficult to know where to begin. But can I start by saying, as other members have said, that the Dignity Party is very concerned that the government is again expecting the Parliament to pass a bill that was in the lower house for all of about 10 or 15 minutes and was not discussed in that house and has arrived in our chamber today with an expectation that we will go through all stages and pass that bill today. I won't rehash the many points that have been made by my colleagues, the Honourable Mr McLaughlin and the Honourable Mr Parnell, and to some extent the Honourable Mr Daly, but I would certainly like to put it on the record that the Dignity Party shares similar concerns. The several submissions on this bill have been read by the Honourable Mr McLaughlin onto the record, and I thank him for that because it means that the rest of us won't have to do the same. But I want it known that I take those submissions very seriously. Usually, Mr. Acting President, the forming of legislation goes a little bit something like this, and I'll oversimplify it because of the time and the lack of time that we have to discuss this bill. But usually, both houses of Parliament, each house of Parliament, the upper and the lower house, will discuss the bill at length after it's drafted, after it's gone through consultation, after it's reached a point where all the relevant people in the community, personal and professional, or civil and professional, are happy with it. It will pass one house, then the other, then it will be assented to, and then it will become law. Then there's a separate arm, the court, judges, magistrates, who are expected to make judgments based on those laws and see how they might impact individual people, individual cases that come before it. So it's the judges or the magistrates' job to judge how an individual law should be handed down to a particular individual person. So it's our job here in the Parliament today, here in the Parliament usually, to make broad laws that apply to everybody, and then it is the judge's job to assess how that law should apply in individual cases. So the judge has to take into account the background of that person before them, the particular needs of that person before them, what led that person to make the decisions that have led them to be before a judge. But interestingly, this evening, Mr. Acting President, the Parliament is being asked, in fact is being demanded, because we've been given no option, it would appear, but to pass this legislation today, the Parliament is being demanded to play both roles. The Parliament, so to pass the legislation that will apply to everyone, ultimately, all 1.7 million people in South Australia, and to be the judge, because we're passing this legislation on the basis or on the strength of a particular, very difficult case. So we're being asked to pass a law that affects everybody in this state because of one person. And I don't deny that it's a very difficult case. I don't deny that it's a very serious case with very serious consequences. But I do very strongly object to the fact that I, as a parliamentarian, and everyone in this room here this evening, is being asked to act as a judge. But not only that, we're being asked to act as judges with less information than a judge would have to do that job. Because as previous speakers have said, we haven't seen the psychiatric or psychological reports that have been made about this particular young person. So we have no information, or very, very little information about their background, one that I understand involves significant trauma, one that obviously has led them to come under the guardianship of the Minister, and that is not something that happens lightly. It is not something that happens overnight. That is something that happens with significant difficulty and trauma in the life of that person. But other than that, we have no detail as to this young person. We know, of course, that they are a young person. In other words, they are a child. They're under the age of 18, which means that their brain technically, psychologically, biologically, has not finished forming. And we know that because of that, they're likely to need significant investment and significant support in trying to rehabilitate wherever possible. It may not be possible. It may be possible for this person to rehabilitate. It may not be. I don't know. I'm not a psychologist, and I'm certainly not a judge, although I'm being asked to act as one this evening. But I do know that it seems very clear from the submissions, the correspondence that I have received, it seems very clear from my perspective that this young person has not been given enough support, enough investment, enough opportunity to rehabilitate. It certainly doesn't appear that the trauma, the significant trauma that they appear to have lived through in their young life, in a child's life, so far, it does not appear that this has been adequately taken into account in dealing with this case. As other speakers have said, I'm also very, very concerned about the fact that ultimately this bill is not even about this very, is not even only about this very difficult and very significant case. As the Honourable Mr. Daly has said, sometimes we do have to deal with cases urgently and without enough time that we would usually expect, the time frame that we would usually expect, but it is usually because there was a case or a situation that is very significant, very serious, and could not be foreseen, and is only about that one case. But in this particular bill, neither of those things are true. Because we know that this young person's detention is due to expire on Friday. I think I'm correct in saying. But we can't possibly accept that it has suddenly occurred to the Department for Prosecutions or SAPOL or the government. We can't possibly expect that they didn't know until today that that person's detention was due to expire on Friday. We can't possibly expect to be expected to accept that that is, oversight that couldn't have been foreseen, that wasn't predictable. When that person was put into detention, this young person, this child, and I'm going to say that word a few times because I think it's important that we remember that we are discussing the future and the life of one person who is still legally, biologically, psychologically a child. I cannot accept that the government, that SAPOL, that the Department for Prosecutions, Public Prosecutions, simply forgot or didn't remember or didn't foresee that that detention period would have a time limit on it that would need to be dealt with long before 3 days before it is due to expire. I also don't believe that this bill is only about the very difficult case of that one young person, that one child, because as other speakers have already said, and as the Attorney General himself has said in the other place, as outlined in the quotes read by the Honourable Mr. Parnell, there are other elements to this bill that aren't to do with the case of this child, that are arguably similar subjects that the Attorney General thought, oh, since I've got this bill going with this one case, I might as well whack it in there, give it a crack, because that's apparently the way that our Attorney General legislates in this place and in this state in 2017. If there's something remotely similar to a bill that you're already drafting, just whack it in there. No consultation, not even discussion in the House where it was introduced and passed in all stages in the lower house in 10 to 15 minutes. So it's not only about this one young person. It could have very serious consequences for all South Australians, particularly all of those who come before the legal system and the child protection system. And it also doesn't adequately deal with the particular circumstances of that one young person. If the Attorney General expects us to act as judge, jury and executioner, then at least put in place measures in that bill that deals with the particular circumstances of the person whom we are judging. That they do have a background of trauma, that they are still under the age of 18, that their brain is still developing, and that they have been failed significantly, it would appear, by the system and by those people, formal and informal, who could rightly been expected to do more if they have ended up under the guardianship of the minister. As I've said, that isn't something that happens overnight. It's not something that happens lightly. It's not something that happens on a whim, unlike the amendments or the additional factors of this bill that aren't to do with this particular young person. It's something that happens to people who have had a great deal of complexity and hardship in their life. So in addition to targeting one particular youth in this case, the government bill also brings into force a range of measures which disregard our human rights commitments, our rehabilitation commitments, and our investment commitments in the prison system, in the correction system. But don't take my word for it, Mr. Acting President. There are a number of submissions which have already been read onto the record, so I don't believe the government will be pleased to know. I don't intend to rehash all of those. But there are a number of submissions that have been prepared under great haste, I would add, because of the lack of consultation on this bill. And those submissions come from the Guardian of Children and Young People in the state, Ms. Penny Wright, the Guardian who has a responsibility for all young people in the situation that this young person finds himself in, but not only that, has actually visited that person and made an assessment on the situation of that young person, which is much, much more than we here in this chamber have had the opportunity to do. And yet we are being expected to pass this bill without amendment if the Attorney General gets his way. But not only does the Guardian for Children and Young People in this state have significant concerns about this bill, particularly the unamended version of this bill, the Law Society submission, prepared as I understand it, only once a crossbencher alerted them to the existence and the impending passage of this bill, points out that in its current form, this bill is in breach of fundamental principles established under the United Nations Conventions on the Rights of Children, the Child, and the Beijing Rules regarding standard minimum rules for the administration of juvenile justice. And I want to say that again. This bill disregards standard minimum rules for the administration of juvenile justice. So this isn't some lofty, abstract benchmark that we're asking the Attorney General to meet here. These are the standard minimum rules. And according to the Law Society, who are much more versed in how to apply laws and how to interpret laws than I am, this bill in its current form doesn't even meet the minimum standard. I note that today the Australian Institute of Health and Welfare has today, fittingly, released figures on young people in child protection and under youth justice supervision, 2015-2016. And those national figures indicate that in Australia, young people in the child protection system were 12 times more likely to also be under youth justice supervision. Additionally, young Indigenous South Australians are 16 times more likely to have contact with child protection and youth justice supervision. These statistics indicate that it is certainly not just about this one young person. It's about a system that is significantly and unacceptably failing many, many young people in this state, including this one young person who is allegedly the catalyst for this bill that we have before us this evening, even though the measures in it go far beyond the case of this one person. So, here we have a situation where the government has not only failed to use the existing provisions that could have been used to deal with this young person under the high risk offenders legislation, for example, to some extent potentially under the Mental Health Act legislation. I don't know, because I haven't seen the psychiatrist or psychologist report about this young person, so I don't know, arguably, whether it is would have been suitable to use those pieces of existing legislation. So that's why we're here tonight, being asked to make sweeping and very severe judgments on this one young person. So the government has failed to use existing provisions. They've failed to limit it to this one young person, because we know the bill as it stands has many features that are not just to do with this one young person. We know that the government and the system has apparently failed to provide this young person with the investment, with the support that may well have seen them not end up in this situation in the first place. Again, I don't know, because I'm flying by the seat of my pants, as we all are tonight, because we don't know the level of information that we arguably need to pass this bill in an informed, comprehensive way. In other words, the information that we could benefit from to actually do our jobs. So, the situation that we find ourselves in is extremely, it's a rock and a hard place. Because like the Honourable Mr Parnell has said, I think there may well be a case to keep some people in detention past the expiry of their sentence, the expenditure of their time, so to speak. But whether or not it is right for this person, I don't feel qualified to say, because I don't have the right information to help me make that judgment, and nor should it be my job, or anyone's job in this room here tonight, to make that judgment. I will say at this stage that I believe the opposition amendments make a completely unpalatable bill and process slightly less offensive and slightly more professional. So I will, at the very least, be supporting the opposition amendments to make sure that this young person and other young people in this situation at least get supervision, as opposed to indefinite detention, with no support, with no investment in their ability to develop, as they are still children. Let me say it again. Still legally, biologically children. But pending the passage of those amendments, well, I'll reserve my right to make a decision about the third reading of this bill after that. But can I just say, at this point, I support the opposition amendments, because I think they make an abhorrent bill and an abhorrent process slightly less abhorrent. And like I'm saying, I'm not denying that this young person has obviously done some very serious things. They obviously need to be dealt with. But I want to make sure, and in fact I feel I would only be doing my job if we made sure that that was being done in a comprehensive way, where every opportunity for investment, for rehabilitation, for support, for the acknowledgement of the trauma in this person's background. Because at the end of the day, if we don't acknowledge that, we're not actually addressing the problem. We're only setting this person down a path of reoffending, of being misunderstood, of being isolated, because no one has acknowledged the real issues that have played a part in leading them to where they are today. Am I saying that with these investments they would absolutely 100% not reoffend? Absolutely not. But I am saying that we owe it to this young person and to everyone in the community to actually do our jobs and make sure that we give every possible avenue the adequate exploration, investigation and implementation. So I'll support the Liberal amendments and reserve my right to make a judgment on the passage for the third reading pending that. Thank you.
The Honourable Mr Brockenshire.
Mr Acting President, sir, I'll be brief because there's still a little bit of other business to